Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. The Seventh Circuit sets a new standard for FLSA collective actions. This deepens a circuit split over notice to potential plaintiffs in these actions and increases the likelihood that the Supreme Court will weigh in. For decades, the Lusardi two-step approach was the go-to framework for distributing FLSA notices, where conditional certification is granted after a facially satisfactory showing of similarity. But the Fifth and Sixth Circuits have recently developed more rigorous standards. The Ninth Circuit endorsed a two-step process in its Cracker Barrel decision, though without opining on what specific standard to apply at the first step. Now comes the Seventh Circuit, offering a middle ground. Under the new Richards framework, plaintiffs must present evidence that creates a material factual dispute as to whether the proposed collective is similarly situated. Before notice is authorized, the employer has an opportunity to show that the collective is dissimilar, and the judge must weigh the evidence from both sides. The Department of Labor relaunches the PAID program. The popular Payroll Audit Independent Determination, or PAID program, allows employers to proactively correct Fair Labor Standards Act violations. It was launched during the first Trump administration, but shuttered during the Biden years. The new version also covers certain Family and Medical Leave Act errors. The PAID program offers an alternative to litigation and liquidated damages, whereby employers self-report violations to the DOL, which will outline any remedies or back pay owed. The program does include eligibility restrictions, and it does not cover state or local claims. And more news from the Department of Labor. The agency has scaled back penalties in wage and hour audits. In the new Field Assistance Bulletin, the DOL has scrapped the previous policy of seeking liquidated damages in pre-litigation wage and hour investigations. The Wage and Hour Division is now limited to supervising payment of back wages and overtime in these claims, restoring the historical practice the agency followed from the 1940s until the Obama administration began seeking pre-litigation liquidated damages. Liquidated damages remain a risk for employers in cases that proceed to litigation. That's it for this week. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.